I want to welcome our witnesses, Chairman Tom Wheeler and Commissioner Ajit Pai from the Federal Communications Commission. This will be the second time, exactly 364 days, since you were both here before, but who's counting? Welcome and thank you for being here today. The focus of today's hearing is the FCC's fiscal year 2016 budget request. The Commission has requested a total of $413 million or $73 million or 21% increase over the current level of funding. Within your fiscal year 2016 request is a $25 million transfer from the Universal Service Fund to augment the Commission's funding. A large part of your request increase is for a potential move from your current location. I have some questions for you regarding the cost of this move. But a 21% increase is far more than most agencies have seen in recent years. While the FCC is fee-funded, these fees are directly passed on to consumers, as is the funding for the Universal Service Fund. Because of this, I believe the committee's oversight over the FCC's activities is especially important, and I take this very seriously. This committee has held the FCC's funding at a flat level since 2012 because we believe that the Commission can and should do less with less. We believe you all should do a better job of managing your resources and focusing on your core operations. Unfortunately, the Commission seems to be pursuing politically charged issues rather than the important mission-critical work of the FCC. I heard Angela Merkel talk about the difference between Europe and the U.S. in terms of Internet regulation. And one of the things that she said was, in Europe, we tell them what they can do, and in the U.S., you tell them what they cannot do. And I think that's interesting because when there's a lot of competition, there's not as much need for regulation. The Internet has been an unparalleled catalyst for innovation, yet the FCC just a month ago voted to constrain and control something that has brought about innumerable technological advances and American jobs. The recent rulemaking puts both broadband Internet and wireless Internet under a 1930s era utility-style regulation regime, which I believe is outdated, backwards, and most importantly, stifles job creation and innovation. These rules will slow down critical broadband investment at a time when our economy is still rebounding. Today's U.S. Internet market exceeds Europe's in both competition and investment. American Internet users have more choices than our European counterparts, and yet we are moving toward a more onerous and restrictive regulation. I don't think anyone could imagine where the Internet would be just 5 years ago. The idea that the FCC is capable of anticipating all possible future innovations, to me, is implausible, and I believe this rule will result in damaging unintended consequences. Aside from the recent rulemaking, we have a number of other significant topics to cover with you all today. Commissioner Wheeler, you're asking for a $117 million auction administration cap to implement the largest incentive auction of our lifetime. Just last year, the AWS-3 spectrum auction closed after 341 rounds of bidding with a record $41.3 billion in revenue raised. The upcoming 2016 incentive auction will match broadcasters who have underused commercial spectrum with wireless companies who need more spectrum due to the so-called spectrum crunch. This kind of auction has never been done before at this level of either complexity or size. The committee fully supports this auction as it is expected to generate billions of dollars of revenue for deficit reduction. However, we are concerned with transparency within the auction administration funds. We also expect this to be fair and open auction so all interested parties can fully participate and to generate the biggest bang for our buck. While I understand net neutrality rules and the incentive auction have dominated the headlines recently, I'm eager to hear from you about the cost of your headquarters move, the Universal Service Fund oversight, and structural reforms of the Commission. The FCC has significant work to do, and I hope that today we can talk about how this agency can be run in an effective and efficient manner. So So I thank you both for the work that you do. Thank you to your staffs, and look forward to your testimony. And now I'd like to turn to my distinguished ranking member, Mr. Serrano, for any opening statement he might make.
Thank you, Mr. Chairman. Before I start, though, you were quoting a European nation telling us how to behave?
I was telling you
Okay.
what a foreign nation said about regulation.
Just checking.
And evidently, we're doing better than they are.
Just wanted the record straight. Thank you, Mr. Chairman. I would like to join you in welcoming Chairman Wheeler and Commissioner Pai back before the subcommittee. We had an interesting hearing last year, and I expect this year's will be as lively as well. The Federal Communications Commission plays an increasingly important role in our society and in our economy. As new technologies have developed, entire new industries and methods of communications have emerged for television, radio, satellite, and the internet, the FCC is the vital link in ensuring fair competition, media diversity, and expanded access to these vital parts of our economy. Unfortunately, the subcommittee has hampered the ability to meet these challenges by forcing the FCC to operate with the same level of funding for the last 2 years. This is having serious negative effects on the FCC's enforcement capacity as well as its abilities to meet the demands of a rapidly changing environment. The agency is now operating at its lowest level of personnel in more than 30 years. That is incredible. If you think about it, over the past 30 years, the FCC has had to regulate entire new industries, but we're only providing enough resources to regulate those that existed 30 years ago. The FCC has had to do much more with much less than is needed. And if we make matters even worse and go back to sequester levels, then we're only courting disaster. In this context, I believe that your budget request is reasonable and necessary. As should be obvious over the past few months, there are numerous important and pressing issues that the FCC is dealing with beyond struggling with artificially low funding. I, for one, strongly applaud the Commission's actions last month to ensure net neutrality and an open internet. I firmly believe that it is of the utmost importance for consumers and businesses that they have assurances that their internet content and access will be treated the same way as everyone else's. This principle is of crucial importance to innovation in our country and to consumers as well. In particular, I want to compliment your efforts to ensure that mobile devices are treated in the same manner as wired devices. A large number of Latinos and African Americans only have access to the internet via their smartphones, and rules without these protections could have negatively affected their access to the internet. Additionally, I hope we have a chance to discuss smartphone theft and, quote, kill switch technology. Since last year's hearing, there has been some important progress on this issue, both at the FCC and within private industry. While I'm pleased with these important steps forward, I believe having a clear, enforceable standard is the best way to ensure that smartphone theft continues to decline. And along with Senator Klobuchar, I plan to reintroduce the Smartphone Theft Prevention Act in the near future. I understand that you both have testified before Congress several times in the past few weeks. I can tell by the looks on your faces. Thank you for the laughs. So some of these issues may be very familiar ground. However, I welcome you to this hearing. I look forward to your testimony. And before I close, let me tell you that I clogged the airwaves this morning because on my iPad, I just said that we were at this hearing both on Facebook and Twitter. So we're working together. Thank you so much, and thank you, Mr. Chairman.
Were you neutral about it?
I was very neutral about it.
Thank you, Mr. Serrano. And I know that our witnesses have been busy for the last couple of weeks, but they've had a weekend to rest up, so they're here today. So, Chairman Wheeler, I'd like to recognize you for any opening statement you might make. If you could keep your remarks within the 5-minute limit, that'll give us more time for questions. The floor is yours.
Thank you, Mr. Chairman. Mr. Crenshaw, Mr. Serrano, members of the committee, thank you very much for the opportunity to be here 364 days later, sir. I'm a businessman, and you're my board of directors, and I'd like to present this in kind of the way that I would present to boards of directors when I was in my previous life. So there are hopefully slides in front of you that I'd like to walk through. The first chart, labeled Executive Summary, on the left shows the current state of affairs for the agency. Our headquarters space is too large and too expensive. Our field footprint is too large and inefficient. And we have major opportunities to reduce our operating expenses through the use of technology. We also have an inappropriate allocation of costs that are burdening those that don't benefit from those expenses. So what we are proposing over on the right side, our response, is a budget with the lowest number of full-time employees in 20 years, the first full-time employee reduction in 10 years, the first review of field operations in 20 years, and a reduction of the big-ticket items associated with the headquarters and contractors. Yes, it's up $84 million. 70% of that is unavoidable kinds of expenses that we'll talk about in detail, I'm sure. 20% of that is for investment that will reduce costs. 10% are things you told us to do but did not fund. And as I said, we tie our expenditures to our activities. Quickly, the next two slides show how the agency funding has been flat while the FTEs have been declining. The next one shows the volume growth in activities while FTEs have been declining. But the important slides then are on 5 and 6, because on 5, we talk about the cost savings that are underway, that the FTEs are the lowest because we're not filling vacancies, that the field office update is crucial. Nobody's looked at it for 20 years. We can cover 80% of the U.S. with 8 offices and pre-positioned rather than the current 24 offices. We are eliminating in the process very high per capita operating expenses. We're cutting the number of contractors through the use of technology. Contractors, as you know, are significantly more expensive than FTEs, and we're going to continue this kind of approach going forward. So if you look at slide 6 and how do we build the budget, the columns are the 3 sources of revenue, if you will. That which we generate from fees on those we regulate, and then the revenue generated from the auction and from the Universal Service Fund. The first 3 items, office move, inflation, and Inspector General request, which are unavoidable expenses, what I've categorized as unavoidable. Actually, if you take those unavoidable expenses out of the bottom line, you'll see that we're actually would be requesting a decrease. Slide 7 is what those expenses look like on a proportional basis, and as you can see, 71% of them are associated with things that we have to do. The next largest is IT, which is how you save money going forward. 5% for the broadband map and a do not call registry for 911 providers, which we were mandated to do but we're not funded to do. 4% to do the broadcast relocation, begin the broadcast relocation work for the incentive auction, and 2% for cybersecurity. Since IT is the next biggest expense after the move, take a quick look, if you would please, at page 8, which is what the IT expenditure allows us to do is, in terms of infrastructure, to move to the cloud, which will save us between $1 million and $2 million a year. Allow us to have a single architecture for our data, which also will increase productivity and reduce operating costs. And allow us to move to a core platform, which again, will save another $1 million to $2 million a year. But the big ticket item, the big enchilada, is the move. And the impact of that is discussed on slide 9. Here's why it needs to happen. We need to move to smaller space, and we need to pay less on a per square foot. We're currently at about 650,000 square feet. We should be in about 475,000 square feet. We're currently paying about $60 a square foot. We should be paying about $55 a square foot. This requires an upfront investment to save $190 million, $119 million net. But you can see the impact over time of what this investment would get us. And then lastly, the last chart is we looked at what does it take, what if we didn't move, what if we downsized in place, and what would that cost? And it actually ends up costing us more because of the rent goes up even higher, the relocation expenses associated with it, details of the cost associated with shrinking offices, office sizes, et cetera. So I look forward to discussing this and any other issues with you. Thank you very much.
Thank you. I'd like to recognize Commissioner Pai.
Thank you. Chairman Crenshaw, Ranking Member Serrano, and members of the subcommittee. It's a privilege to appear before you today. Thank you for inviting me to testify on the FCC's budget request. Although all commissioners are asked to vote on a budget proposed by the chairman that is delivered to the Office of Management and Budget, I've not been asked to participate in the development of the agency's budget request. Unfortunately, after reviewing this proposal, I'm unable to support it. To be clear, this subcommittee should give the FCC the resources necessary to carry out its core responsibilities. The FCC staff is filled with talented individuals who are dedicated to serving the American people. And we tackle a wide variety of tasks assigned by Congress, from freeing up more spectrum for mobile broadband to protecting public safety. But the Commission is requesting a baseline budget of $413 million, a 17% increase over last year. That is dramatically higher than it has been at watershed moments in the FCC's history. For instance, the agency's baseline budget, after adjusting for inflation, was only $277 million when it faced the monumental task of implementing the Telecommunications Act of 1996. In that light, the current request is not fiscally responsible. And so I would like to offer 3 specific suggestions for improving it. First, I do not favor transferring $25 million from the Universal Service Fund to the Commission. Put simply, this is a stealth tax increase on the American consumer. The money that goes into the fund comes out of the pockets of consumers when they pay their telephone bills each month. And this proposal would require those consumers to pay an additional $25 million this year. That amount would be on top of the $1.5 billion annual tax increase that the FCC adopted last December to fund additional E-rate spending, which will go into effect later this year. Since the beginning of 2009, the Universal Service Contribution rate, that is the FCC-imposed consumer tax rate, has already jumped over 83%. Congress should not take action to push it even higher. Second, funds for moving the FCC's headquarters or reorganizing how we use our existing facilities should not be included within the FCC's general budget authority. Over the long term, moving or reorganizing is likely to save money, but the funds that we spend on that effort will be a substantial one-time expense. I therefore believe that it makes sense for Congress to give us specific budget authority for this purpose. If these funds are included within our general appropriation amount, it may paint a misleading picture of our baseline budget and make it harder to reduce that budget when there's no longer the need to spend money on moving expenses. Third, Congress should forbid the FCC from using any funds to implement or enforce the plan it just adopted to regulate the internet. Not only is this plan bad policy, absent outside intervention, the Commission will expend substantial resources implementing and enforcing rules that are wasteful, unnecessary, and affirmatively detrimental to the American public. Heavy-handed regulation does not come cheap. The FCC has already wasted millions of dollars on this unprecedented action, and we are on course to waste millions more. The implementation and enforcement of these new rules will not only impose significant burdens on the nation's thousands of internet service providers and harms on consumers, They will also consume substantial FCC resources. In my limited time, I'll offer just one example. The order allows parties to seek advisory opinions from the FCC's Enforcement Bureau. Given the breadth and vagueness of many of the new regulations, especially the new Internet Conduct Standard, I expect that many parties will seek clarification. Drafting advisory opinions will require careful consideration of the circumstances involved in each and every request. This inevitably will be resource-intensive. The Bureau must process each request, review the facts behind each filing, make a decision, and then draft an opinion, which will undergo layers of review. And since the Bureau lacks specialized expertise in this particular area, it will likely rely heavily on the expertise of other bureaus, especially those that helped craft the order. At a time when the FCC is struggling to fulfill some of its core responsibilities under the Communications Act, it should not spend millions of dollars to regulate the Internet. This subcommittee is well aware that budgets are finite. Funds spent on regulating the Internet are, by definition, funds that can't be spent on critical priorities. So instead of trying to fix something that isn't broken, let's use our limited budget to fix something that is broken, such as the FCC's information technology systems or its widely panned, user-unfriendly website. Chairman Crenshaw, Ranking Member Serrano, members of the subcommittee, thank you once again for inviting me to testify. I look forward to answering your questions and to working with you and your staffs in the time to come.
Well, thank you very much. And let's begin the questions. And we've got a full house, and I know there are a lot of questions. So let's try to observe the 5-minute rule, both from the questioner standpoint as well as the responder's standpoint. Let me talk a little bit about net neutrality and ask, first of all, Chairman Wheeler this question. It's been pointed out that you've been over here in Capitol Hill testifying quite a bit recently. And you know that Chairman Upton and Chairman Thune are working on legislation in this area. But ultimately, the funding that allows the FCC to work on any rules, like net neutrality, comes from this committee. That's where the money comes from. And we have kept your funding purposefully low for a few years in hopes that the limited funding would push you all toward prioritizing the most important work of the agency. But instead, it seems that this agency has prioritized politically polarizing rulemakings at the expense of some of the statutorily mandated and other important work that this agency has to do. Let me give you a couple examples of statutorily mandated work that seems to be taking a second seat. There's a section that requires the Commission to annually report to Congress on the status of competition in the market for the delivery of video programming. And this Commission didn't issue such a report last year, even though the statute mandates that. There's another section of the Telecommunications Act that says that you have to annually initiate a notice of inquiry concerning the availability of advanced telecommunications capable to all Americans. Now, that notice was initiated in August in 2012, but the report wasn't finalized for another 2 years. And then lastly, there's a section that requires the Commission to report every 3 years on statutory and regulatory barriers to small businesses. And that last report was back in 2011. And so it seems to me that this net neutrality rule may have bumped into a lot of the statutory requirements that are there on the books. And so I have to ask you, Chairman Wheeler, can you figure out how much time, how much energy, how much money was spent on working on these net neutrality rules? And then the question is, do you believe that you've spent some of the resources on this rule at the expense of some of the other work that this Commission is supposed to do? Chairman Wheeler.
Thank you, Mr. Chairman. You know, you mentioned, for instance, the video competition report, which was a reality that I walked into where there weren't the votes on the Commission. The report got done, but there weren't the votes on the Commission to adopt it. So what I said was, okay, let's stop the process and let's go to the next iteration, meaning we have to start again as to how do we find consensus inside the Commission on this report, and that I promised to the Congress that this would be done in less than the requisite time for a new report. And so we will have the new iteration of that to the Congress in June of 2016. But this is, one of the challenges we have is we do need to get the requisite number of votes of, as I said at another hearing that Commissioner Pai and I were at, 5 Type A individuals. But just to discuss specifically the open internet order. I mean, the fact of the matter is that the internet is the most powerful and pervasive platform in the history of society. And there becomes a basic question of, do you have rules and do you have a referee? You mentioned the bill that...
Let me encourage you all to kind of be concise, because the question is, I mean, you can tell me whether, I assume you don't think that you've spent any time and money and energy on the rule that would have been better spent on other.
I think we have prioritized correctly, sir, if that's your question.
Thank you. So, and then let me just ask Commissioner Pai to kind of respond to that. Not overall the rulemaking, how it's going to impact consumers, but just you think there's some other things that might have been prioritized instead of the time and energy spent on this rule?
I do, Mr. Chairman. I would respectfully disagree with our chairman in terms of the priority that net neutrality received. I think that by definition, net neutrality took our eye off the ball of some of the other critical priorities, removing barriers from infrastructure investment, embracing the IP transition, getting more spectrum into the commercial marketplace, both licensed and unlicensed. I think the staff that spent an inordinate amount of time and effort on net neutrality could have been focusing on those priorities. And ironically enough, the Title II net neutrality order takes us in the opposite direction. It adds barriers to innovation and investment, and it will actually reduce competition in the marketplace.
Thank you. Mr. Serrano.
Thank you. I was not going to speak about net neutrality at this point, but I didn't think it would come up this early. Silly me. First of all, I've been in Congress 25 years, and most of the time, I would say, high amount of time, when the other party doesn't agree on an issue, I may not agree with them, but I understand what the issue is and what their complaint is. I really don't understand the opposition to net neutrality and the rules. To make it open, to make it better, to diversify it, to give people at the bottom a shot at having the same protections and the same freedoms as people who are more powerful in the society. I don't understand what the argument is. And in addition, I don't understand the argument of the conspiracy theory that for some way the president had inappropriate influence on the net neutrality rules that were just released to give internet users the strongest protections possible. So I would like, Chairman Wheeler, for you to please talk a little about the public input and how it influenced the Commission's decision. And just let me tell you that in front of me, and for the record, Mr. Chairman, although they were addressed to us, I have letters from the Alliance for a Just Society, Black Alliance for Just Immigration, Black Lives Matter, Center for Community Change, Center for Media Justice, the National Rule Assembly, and they all were in favor. So what role did the public play, and is it the way I think that the public played the major role in the input for the final decision?
Thank you, Mr. Serrano. I mean, I think it's fair to say that this is the most open and transparent proceeding in the history of the Commission. We had 4 million comments from Americans, never any of that kind of outpouring. And that basically it seems as though things have boiled down to a situation where you have 3 major companies, Comcast, AT&T, and Verizon, differing with other internet service providers such as Sprint, T-Mobile, Cablevision, Frontier, small rural carriers, the Competitive Carrier Association, the small wireless carriers, and differing from what we heard from thousands of entrepreneurs who said they needed to have an open internet, and investors saying that they couldn't invest if there wasn't an open internet, and those millions of inputs. So there was a full discussion of the issues involved, and I think the American people fully expressed themselves as to the importance of this, the most important network we've ever seen.
Thank you. Commissioner Pai, I give you an opportunity to disagree with everything he said.
Thank you, Congressman, for the question. I begin from the proposition that everybody believes in a free and open internet. And the good news is the internet has been free and open for some time. One of our Democratic colleagues put it well at a hearing last week. Our internet economy is the envy of the world. And I would argue that we have reached this stage precisely because of the bipartisan consensus that started in the Clinton administration, that the internet would thrive free from government regulation. And I think that what part of the problem is that the FCC in this case is regulating to solve a problem that simply doesn't exist. Now, the question is, how do we incentivize more broadband competition? That is a topic on which I think there are critical policies that we should be adopting. That goes to some of the policies that I mentioned in my response to the chairman. Those are things that could give people more choices, better speeds, lower prices. Unfortunately, Title II, the FCC's order, takes us in the opposite direction. It saddles some of the smaller providers with the regulatory burdens that they're going to be unable to comply with, and it disincentivizes some of the bigger ones, the ones who are responsible for the majority of our capital expenditures, from taking those risks. And we see the example in the comparison with Europe, which I know you referenced in your colloquy with the chairman. Over the last 3 years, United States capital expenditures have been 73% higher than Europe's in terms of broadband investment. And I would argue that's precisely because we've historically had a more free market approach, whereas Europe has embraced the utility-style approach, which, ironically, the FCC just adopted.
Could I just do one clarification on that? Because the difference between us and Europe comes down to the concept of unbundling. What Europe does wrongly, I believe, is to say that somebody goes out and builds the infrastructure, and then they have to turn around and unbundle it. And we specifically say that we do not do that in this order, and specifically remove from the order that part of Title II which authorizes a future commission to be able to do that.
Right. Mr. Chairman, I know my time is running out here, but let me give you my personal view on something. You know, there's a big statement that's always made, if it ain't broke, don't fix it. But some things are so important to us that even if we think they're not broke, they need tweaking, they need adjustments, they need oversight, they need support, they need growth. And I give you as an example the New York subway system. For years, it ran so well that everybody said, leave it alone. And then it got into crisis. Why? Because it got old, the infrastructure got old, and no one had paid attention to it because it ran so well. Now it's doing much better. But so I think that even if the internet is the greatest in the world, to make it better and more available and safer if we use and properly use is only to our advantage. And that's why I believe that what was done by the commission is the right thing to do, and we should all embrace it. And I thank you, Mr. Chairman.
Thank you. Mr. Yoder.
Thank you, Mr. Chairman. Well, I don't know how expanding government's reach and control over this great economic boom we've had with the internet will somehow make it better. And I can't imagine that turning the internet into a regulated utility somehow will unleash investment and job growth in a way that hasn't already occurred. In fact, I think it will precisely do the opposite. Commissioner Wheeler, I'd like to continue on your budget proposal. And I thought Chairman Crenshaw asked a very important question regarding what the priorities of the FCC are and where our dollars are being spent. And his question related to all the resources that were expended and an estimate maybe you could give regarding the resources expended to regulate the internet like a common carrier over these past few years that result in the rulemaking. But I'd like to know, as we go forward, I think your statement was you expect lots of litigation. Excuse me, the big dogs to sue, I think was your quote at one point. Knowing of that litigation risk, do we know what that will cost the FCC, will cost the government? What are the future expenditures? Chairman Crenshaw asked about the past expenditures. I'm interested in the future expenditures, and will that fall under your pie chart here under unavoidable costs, what are those unavoidable costs to taxpayers?
Thank you, Mr. Yoder. We maintain a litigation staff at the agency because no matter what we decide on whatever issue, people turn around, as they have a right to, and ask the court to review it. That litigation staff is in place, and that is the litigation staff that would be used to handle things.
Commissioner Pai?
I do think that the litigation component is one part of the cost that will be involved, but I think there are also other important elements as well. The subsequent rulemakings, the FC order tees up a number of other regulations that are going to have to be adopted, the adjudication of any complaints that are filed with the commission, as well as any advisory opinions that the Enforcement Bureau is called upon to render.
So if the FCC could at some point estimate what they think, and we might have different estimates of what this will cost, but we'd appreciate to know because we'll have to figure out a way to pay for the expense with implementing these rules in litigation. One of the other concerns I have heard from many relates to taxes that may go up related to the government's designation of the internet as a regulated utility, therefore making it eligible to be taxed under the Universal Service Fund. And I would be interested to know, does the commission intend to use its new powers to impose these USF fees on the internet?
Well, as you know, Congressman, there's an exemption from making that decision. We did not make that decision in this order. There is underway a review of the contribution schedule for Universal Service Fund that is being done by both a committee of both state regulators and federal regulators, and they'll be giving us a recommendation. I think it is incorrect, however, to say that anything in what we have done will lead to an increase in universal fee contributions, because the amount of the fund is set by the agency, is not set by what happens in terms of a Title II determination. And that's the important thing to bear in mind, that number remains fixed, that number does not increase because of the fact that we have done a Title II reclassification.
So just so I understand your answer, the commission hasn't decided whether to apply the USF taxes to the internet.
And if it did, based on the federal state board recommendation, it would be not changing the numerator, but changing the denominator.
It would change who pays, for sure.
Which would have a negligible effect on consumers, if at all.
Well, at this point, those fees aren't being charged on internet services, and they would be. Do you know what that total would be?
You would pay it, if I can, you would have a reduction in one area that may be accompanied by an increase in the other that should end up washing out because the gross number is the same.
Commissioner Pai?
I do think that the order explicitly opens the door to the imposition of Universal Service Fund taxes, and the only thing the order assures the public is that those taxes won't increase on the date of the effective date of the order itself. But I do think the writing is on the wall with respect to the Universal Service Fund, given some of the promises the agency has made with respect to the programs that are administered under the Universal Fund, E-rate, for example. Secondly, also, it's important to remember that the reclassification of broadband as a telecommunications service itself triggers a number of other taxes, state and local property taxes, for example. Heretofore, unclassified broadband providers are now going to see a boost in their property taxes, which will have to be borne by the consumer. Additionally, there are a number of other fees that are going to have to increase. Pole attachment rates, for example, those too will be passed on. And so reclassification is sort of the first step down the hill, if you will, in terms of the tax rates that Americans pay for broadband.
Thank you, Mr. Chairman. And I would just ask if the FCC could somehow calculate the increase in costs and fees, local, state, and federal, that will be passed on to taxpayers and users, and be able to pass it on to the committee.
If I may, one independent study from the Progressive Policy Institute has put that figure at $11 billion per year.
Thank you.
And if I may, that specific one study was given 3 Pinocchios by the Washington Post.
Sounds like we'll have time to continue to discuss this. Thank you, Mr. Chairman.
Thank you, Mr. Hood. And let me recognize the chairman of the Communications and Technology Subcommittee of Energy and Commerce, Mr. Walton, who has joined us today. Appreciate your interest. Now let's recognize Mr. Quigley.
I would also like to welcome him.
Thank you, Mr. Chairman. It's good to see the Pinocchio caucus is in session. Gentlemen, thanks for being here. A couple quick points. Mr. Chairman, the auction that needs to take place, the allocation to handle this is about $1.75 billion to the Television Broadcaster Reallocation Fund. Estimates we're hearing now it's about $1 billion short. Our concern is who's going to have to make this up. Your thoughts on that?
Thank you, Mr. Quigley. The Congress said that the max that we can spend is $1.75 billion. And we will adhere to those rules. Some broadcasters have estimated that it could be more. Everybody has their own set of figures, if you will. If it's possible, the Congress could adjust that number, but our challenge is we have to live within the number we were given in the legislation.
If it fails to be enough, are the broadcasters the ones that would have to make this up, on your thoughts?
Well, the fascinating thing is it really is going to depend on how many broadcasters sell and how many broadcasters stay, and it's something where the variables that go into the equation determine what the outcome of the equation is, and so anybody picks any set of variables and then come out with a number that they want.
Well, what would you recommend if there is this kind of shortfall? Congress come up with more? Or?
There have been efforts that we have been engaged in to see if the wireless industry could create some kind of an insurance fund, if you will, because after all, they're the ones who are going to be ending up getting this spectrum. And they have thus far been unwilling to do that. But I think that clearly, if we end up in that kind of a situation, then we have to look at what those solutions might be. That's one. The congressional approach that you suggested is another. But I understand the reality that you're saying, and again, it's the variables in the equation that end up determining the answer.
And given a short period of time, could you give me a couple minutes on how we've done improving on different topic, positive train control issues? You have played an important role in implementing that.
Thank you, Congressman. I think we've made, when I was before you last year, we had our hands full so far as how we were dealing with the necessity for the railroads to get approval to have towers for positive train control along their tracks. We had made spectrum available. We had facilitated spectrum license changes, but the problem of the poles was a big one. And this is because there were requirements that Native Americans had the ability to approve the placement of those poles. We have, working with the tribal communities and others, have developed an expedited process that I'm really proud to say we are now in a situation where we have the capacity to handle more applications for those clearances required by law than the railroad industry has been able to fill the pipeline with. So I think that we are over the hurdle. It was a serious challenge that I do not want to make light of.
No, and it's very important to my passenger and the freight industry across the country. And Mr. Pai, if you want to add to this, your thoughts?
No, I commend the chairman for the steps he has taken, and I agree that it is a critical matter that requires a lot of disparate parties to work together. And the good news is that we do seem to be working toward a common end.
Yeah, and at some point we've got to come to the realization that people aren't going to meet the deadline at the end of the year. We're extraordinarily concerned about the safety issues. We're going to have to find a way to move forward that doesn't blindside the industry and hurt our passenger rail as it moves forward. And just briefly, for both of you, I appreciate your thoughts on net neutrality. I know the passion that's out there is extraordinary. Mr. Chairman, I tend to agree with where you are on net neutrality, But I am listening to everyone, even those emailing me from their parents' basement with a Star Wars figurine staring back at them. I have never seen such intensity about this issue, but we've got to get it right. Thank you, Mr. Chairman. I yield back.
Thank you. Mr. Graves is recognized.
Thank you, Mr. Chairman. Gentlemen, good to see you today. And I appreciate Mr. Quigley's comments there, and certainly this issue we'll talk about today. And you guys have made your tour, I know that, around Capitol Hill, and I want to just drill down a little deeper if I could today. So, Mr. Chairman, forgive me for directing my comments or questions to Mr. Pai, but I'd like to do that because, Mr. Pai, you've been on record very vocal and recently and a lot of different statements in opposition to net neutrality, and I think you'll find there are many members of this panel that agree with your position there as well. But I wanted to see if you could help us a little bit more with more detail, more specifics, because your quotes are very bold. In fact, you said the Commission's decision to adopt President Obama's plan marks a monumental shift toward government control of the Internet. It gives the FCC the power to micromanage virtually every aspect of how the Internet works. You also said the claim that President Obama's plan to regulate the Internet does not include rate regulation is flat out false. You've also said it's detrimental to the American people. That was in your statement. But then on the other hand, we have the chairman and Mr. Serrano and others, and I mean Chairman Wheeler, Mr. Serrano and others, who disagree with your statements. And they say this is not the case, that the FCC will not be able to rate regulate, control the speeds and services. And the chairman briefly mentioned that there are only 3 major companies in opposition that have been outspoken. So if you could just help this panel hear more from your perspective and drill deeper with the specifics as to your statements and away from the platitudes, but a little bit deeper. How will this impact the American people and business and the economy negatively in your viewpoint here?
Thank you for the question, Congressman. I'll tackle each of them as I understood them. First, in terms of the breadth of the FCC's Internet regulations, it does in fact regulate every part of the Internet. Now, traditionally, net neutrality is meant to encompass the relationship between an Internet service provider and a customer, the so-called last mile of connectivity. But this plan goes far beyond that. For example, it sweeps into its regulatory ambit interconnection, the relationship between Internet service providers and edge providers, going into the very core of the network. It applies to that relationship Section 201 of the Communications Act, which allows the FCC not just to regulate rates, which I'll get to in a second, but also to even specify the physical connections that have to be made and the through routes, as they're called, over which traffic has to ride. And that's in the text of Section 201 itself. That is something that the FCC, no government agency, has ever done. Similarly, with respect to service plans, forget about the infrastructure itself, the agency is now arrogating to itself an incredible amount of power that it's going to be wielded in uncertain ways. And so, for example, under the Internet Conduct Standard, the FCC now puts on the chopping block various service plans that have generally been beneficial to the American consumer. Things like T-Mobile's Music Freedom, for example, which allows customers to stream music onto their smartphones exempt from any data caps. The FCC explicitly says that this is a practice that may or may not violate net neutrality. And so if you're a wireless entrepreneur going forward, especially one trying to make a splash in the marketplace against the big guys, your ability to compete is going to be restrained because you don't know whether or not that service innovation may be prescribed. And I think it's telling that after the FCC adopted the order, the agency admitted itself, quote, "We don't really know how this particular standard is going to play out." The second thing you mentioned was in terms of rate regulation. Now, the order goes to great pains to say that we don't engage in ex-ante regulation before the fact, tariffing, the adoption of a cost methodology, and so forth. But it explicitly leaves on the table ex-post regulation. It invites complaints, for example, both to the Commission and to federal court about the justness and reasonableness of rates. And I think what you saw last week before the Senate Commerce Committee was an acknowledgement that, yes, the FCC determining whether or not rates are just and reasonable is essentially rate regulation. that is ultimately going to be to the detriment of American consumers. Additionally, to the point with respect to who is opposing this, we have not just heard from the big boys, as has been said. We've heard from a great many small providers. 24 small ISPs, for example, each with less than 1,000 customers, wrote to us and told us that Title II would be the wrong solution, including Main Street Broadband in Cannon Falls, Minnesota, which has 4 customers. We heard from a great variety of municipal broadband providers, government-owned projects, including some that the president himself endorsed, who said that Title II would be a, quote, tremendous mistake. We heard from countless wireless ISPs who, without $1 of federal subsidies, give people in my home state of Kansas and your state of Missouri all kinds of options they wouldn't have otherwise. And so I think from the standpoint of competition, ironically enough, Title II takes us in the opposite direction from where we want to go. And I think, I hope I answered the questions that you teed up to your satisfaction.
That's very helpful, and I appreciate your explanation there. And then we go through this proceeding, I would hope that both of you would stick to really help us with the specifics as to how this impacts the American consumer, because take it from the political partisan side and move it into the details, and I appreciate your specific answer. Thank you very much.
Thank you. Mr. Bishop.
Thank you very much, Mr. Chairman, and again, welcome our witnesses. I'd like to explore something, minority participation in your spectrum auctions. According to your budget request, the FCC has conducted 85 spectrum auctions. It has granted 39,780 licenses for a total of over $53 billion between FY94 and FY14. I am concerned that small businesses, in particular minority-owned businesses, may not have the same access to take advantage of these high-capital public auctions to the extent that large corporations do. Do you have a plan to encourage the participation of minority-owned businesses, and what is this plan? What information do you have on the participation of minority-owned businesses in past auctions? And what are you doing with this information when planning future auctions? And I'll just go ahead and add a second question on a somewhat different topic, and you can address both of them in the interest of time. It's recently come to my attention that the reclassification of the ISPs under the new open internet rules may lead to an increase in the fee that cable companies pay for attaching their lines to utility poles. What is your take on this, and how do you think that this will impact consumers?
Is that to either one of us, or what do you?
It's to both of you.
Okay. So let me see, I'll handle the first one. I know you have already spoken on the second one, so you can handle the second one, okay? The Congress has said to us, insofar as unique so-called designated entity groups are concerned, that we need to make sure that there are opportunities in the auction. This was a decision that Congress made in 1993. There have been significant changes in the market since then. In 1993, anybody could create a wireless company and go out and compete. Today, the chances of, the Bishop Wireless Company being successful against the behemoths is pretty slim and non-existent. So we have to ask ourselves the question, how do we maintain the mandate of Congress, or the instructions of Congress, to create these opportunities in a changing environment? And so last November, I think it was, I moved a proposed rulemaking to address this specifically with the upcoming incentive auction in mind. Yesterday, I issued or I sent around to my colleagues for their vote a public notice expanding that inquiry, not necessarily expanding, I'm sorry, making sure that in that inquiry we are addressing key questions that have been raised as to the operation of the designated entity process in the most recent AWS 3 auction. We need to get through those processes before we begin the spectrum auction next year. We will get through those processes, and I think that the Commission, I won't speak for my colleague, but I think the commission is united in its belief that we do need to make sure that our rules are updated for designated entities.
Congressman, I would agree with the chairman, and I would add that the AWS-3 auction in particular highlights the danger of not implementing serious reforms towards designated entity rules. In that auction, as you may know, a Fortune 500 corporation gamed the system and used two shell corporations essentially to claim $3.3 billion in taxpayer subsidies. Now, that's a bad deal for the taxpayers, but critically, going to your question, it also squeezed out a number of small businesses, many of whom might have been minority-owned, we're not sure, who either didn't get a license altogether or had to just relegate itself to other areas of the country where it could compete. And I've listed in a public statement a number of those companies who were seeking a license but got outbid essentially by this Fortune 500 corporation. And so I think it's critical for us to implement some strict controls to make sure that this program, so long as it remains on the books, really benefits small businesses, in particular the disadvantaged businesses you identified. The second part of your question was a very important one. In that regards to the rates that cable companies and others pay to attach broadband equipment to utility poles. One of the unfortunate things about the FCC's order is that instead of those companies having to pay what is called the 224D rate, which is a cable broadband rate, they are now considered to be telecommunications providers, and so they're going to pay the higher 224E rate that applies to pole attachments by telecom providers. And there's one estimate that small cable providers in particular, as mentioned by the American Cable Association, will have to pay $150 million to $250 million each and every year for those higher pole attachment rates. Those attachments are going to be, that rate is going to have to be passed on to the consumer, and a lot of these companies serve underserved communities that already lack broadband options as it is.
Mr. Wheeler, you got 30 seconds.
Thank you. The interesting thing is that I was involved when I was president of the National Cable Television Association in passage of the pole attachment law because the cable operators weren't being allowed on. Now what we're finding is that cable operators are saying to new competitors, and others are saying to new competitors, you can't get on because you're not a telecommunications provider. And so the fascinating thing is what we are doing is opening up access to poles that the current incumbents have been behaving exactly how the anti-cable people were behaving 20, 30 years ago. And what we've done is open it up so that competitors do have a chance to get on the poles.
Thank you, Mr. Chairman.
Thank you. Mr. Ridgel.
Thank you, Mr. Chairman. Thank you both for being here. I had the opportunity to meet with Chairman Wheeler privately, and I appreciate the time that you spent with me. It was helpful to me. So I want to direct my questions to Commissioner Pai, and thank you for being here today and your service on the commission. And I do so, these questions are designed really to test my understanding and to improve my knowledge about this topic. It's not to make a point, but I got a call a couple of days ago from a good friend of mine. He's in this industry. I respect him greatly. He's well-read, and he was really livid. I had to kind of hold the phone away from my ear because he was just livid about this decision. And he was really focusing on the process by which the rule was advanced. And you know, he was saying that this was basically unprecedented, and especially the final rule, how it was actually rolled out without a comment period. But yet I also know, I heard from Mr. Chairman Wheeler, we went into this extensively, you know, 3 million people, you know, provided their input here. So help me to understand what if anything, was unprecedented. Let's set aside the allegations about the administration. I want to set that aside for a moment. Just look at the rest of the process. Was there anything in it that you were very troubled by? And if so, what? I noted it was not in your opening, your written testimony here today.
Thank you for the question, Congressman, and I'd be happy to include in the record my dissent, which includes a full list of some of the procedural problems that I see with the
Hit just one or two substantive ones, because I don't have a lot of time.
Sure, absolutely. First and foremost, the FCC never proposed Title II as a solution to this alleged problem. The original proposal in May of 2014 was based on Section 706 of the Telecommunications Act, which is a somewhat lighter solution. Moreover, after the President made his announcement on November 10th, even then, the FCC was considering a so-called hybrid proposal. Only on February 5th did it become clear that Title II was going to be the course the agency pursued.
Is this a substantive difference? I mean, I'm not a lawyer, but I mean, when people were commenting, I guess guess this would be somewhat directed to Chairman Wheeler. I can roll back around here, but were they commenting on the rule that is now before us and that we're commenting on, or were they commenting on something that was not relevant to the final rule?
By and large, they were commenting over the spring and summer of last year on what they thought the proposal was or should be. No one in the public was able to see the proposal. That
The full
was on the
scope?
table. I'm sorry?
The full scope was not out there.
The FCC never made the plan public until a couple of weeks after it voted on it.
Well, I'm on a relentless pursuit of the facts around here, and I think other members are as well, so I don't believe that I'm the only one, but it's really tough to get to the bottom of some of these things, because 3 million is very compelling if you don't hear it in context. But you make a good point. I want to move over to just to the substantive side of this thing for a moment. Regulation of the internet is unprecedented, but so is this notion of providers throttling and blocking. Now, let's just give you a hypothetical scenario, rule setting where the capacity is running at maybe 60%. People are watching Netflix, everything else, everything's just running smoothly. Now, do you believe that that single source provider, they don't have any other options, that provider should be able to throttle or block because they got a good deal with Netflix and to be able to charge more because of that? Is that your view?
Congressman, that's an important question. First, there's no evidence in the record that that actually occurs. So that's from a standpoint of regulatory rulemaking. It's important to remember we don't rule make.
But the notion that some providers would throttle or block, this is not just a hypothetical. I mean, it's been talked about by major providers, has it not?
It has not been. No, none of the major providers.
I mean, is throttling and blocking just something I imagined?
It's nowhere in the order, Congressman.
Not in the order, but I mean, I'm talking about in the marketplace. I'm a proponent of a marketplace environment, but that is not often the case with broadband providers, especially in rural markets. This is why I'm really trying to get this right and work through it. In fairness to the chairman, I think I owe him at least 30 seconds. Chairman, if you would address this idea that the comments were not really about the substance of the rule. That would be troubling to me because you're quoting it as if it is.
Thank you very much, Congressman. During my tenure, what I have tried to do is to put forward a rebuttable presumption, the key thing being rebuttable, and then to raise all kinds of other issues in the notice and saying, we want your comment on this. Because what a rulemaking should be is an evolutionary process, as you say, that gets everybody's input into it. Not that comes down and says, this is what it's going to be. And so what we had was a very evolutionary process. And the question of Title II was asked repeatedly in the notice of proposed rulemaking, number one, and commented upon repeatedly by members of Congress and all of those who filed in the proceedings. So there were no surprises in that regard. And let me just, if I can go to the blocking and throttling question real quickly. Congressman Walden, I guess, has left, but in his bill, he says no blocking, no throttling, and no paid prioritization. A Republican commission in 2002 started this whole thing going by saying to Comcast, you are blocking and you shouldn't. Last August, Verizon moved to throttle wireless speeds, and I had to go to them and say, wait a minute, this isn't right. And they, to their credit, backed off, but they were starting to say, if you buy unlimited service, I'm going to throttle you. And on the question of paid prioritization, there's two things that are worthy of note. One is that Verizon's lawyer in court said specifically, I have been instructed by my client that I may say that one of the reasons we're appealing the earlier rules is we want to do that. And secondly, in response to a specific request from Senator Leahy, the major ISPs refused to say they would not prioritize for pay.
Well, I thank you both. I'm well over my time. The chairman's been very gracious. I yield back.
Thank you. Mr. Fattah.
Thank you, Chairman. Chairman Wheeler, let me start at a different place. Connect Ed, which is a effort that I think should be applauded throughout the land in terms of connecting up our young people in their schools with access. And you got a lot of private sector partners, and it seems to be well on track. If you could take about 60 seconds and tell me anything that's important for us to know about where you are in this.
Well, we have finished a rulemaking in the last 3 or 4 months that expanded the E-rate program to connect schools. About 2/3 of the schools in America did not have high-speed connections. And so we are facilitating those connections down to the student's desk, because it's not just the fiber to the school, it's the Wi-Fi to the desk.
All right. Is any, the administration has just announced a broadband summit. I was with the president yesterday at Select USA, which was it's some 2,700 people, guests from around the world, who are interested in direct investment in our country. And one of the selling points that the president made was the tremendous expansion of broadband in our country, in rural and areas that heretofore haven't been served. And it was a major selling point. Some $13 billion was invested by these friends, these guests in companies here. And in part, your work is laying the foundation for that. And so this broadband summit how will your role be, the FCC's role be in this effort to further expand broadband?
So our goal, Congressman, in the whole open internet proceeding was not only to make sure that the internet stays open, but also to make sure that there are incentives for business people to want to invest in competitive, ever faster broadband. And that's why we specifically did not rate regulate and patterned what we did after what has been so wildly successful insofar as wireless voice services were concerned, where the wireless voice industry asked to have Title II and forbearance, and were wildly successful thereafter.
All right, and the last point is now I represent Philadelphia. I represent Comcast. It's in my district, the largest employer. So I understand that they have a viewpoint on these matters, but Americans have expressed some viewpoint on net neutrality. You took in public comment, and was it 3 million, or how many people commented on both sides of this?
It was about, there were roughly 4 million total, and the comments ran basically 3-to-1 in favor of open internet. And
so, you know, I would just stop here, Mr. Chairman, and ask your counterpart, who I understand represents the different point of view on this. Do you think that these 3 million Americans, that their voices should be heard on this matter?
Absolutely, Congressman. I think all of them should be heard. And
so in our democratic system, do you think 3 million might even, you know, even someone in my position, I represent a city in which one of the largest business concerns doesn't think this is a great idea, but you know, 3 million Americans is pretty substantial.
I agree, Congressman, but I think what is critical is providing more competition in the marketplace rather than heavy-handed regulation, which counterintuitively would disadvantage many of those 3 million consumers.
You're saying that you want to think on their behalf in this matter? Do you think they're wrong?
Well, what I think is that Title II takes us in the opposite direction from the goals that they espouse.
You think that their views should be honored by the Congress?
Meaning, I'm not sure what.
They have a position that's contrary to yours.
Mm-hmm.
And on a 3-to-1 basis, I'm saying, do you think we should take that into consideration in the United States of America?
Well, Congressman, as you and your colleagues know, might does not make right in Congress, and same at the Regulatory Commission. And
So you think we should overrule them?
I do. I do think that the agency
Thank you.
should focus on broadband priorities.
I appreciate you, and I appreciate you standing up for what you believe. Thank you, Mr.
Thank you,
Chairman.
sir.
All right.
Also, I would just point out that we didn't hear from 307 million Americans, so we don't know what they said either.
Mr. Chairman, you're absolutely right. I remember when the president said in the last election, 2/3 of the people didn't vote, but the ones who did said, you're going to chair this committee. They're going to respect that, all right?
I believe in democracy.
I also remember an election that was decided in Florida by 500 votes, even though the other guy had gotten 500,000 more votes.
Mrs. Herrera Butler, you're recognized.
On that, one thing, you know, we have this whole argument about who spoke up and who didn't speak up, I feel like it's kind of, unfortunately, because of the commission's actions, it seems to have been rendered moot. Because what I understood from the timeline, and this was one of my questions for Commissioner Pai, is that the commenters and the people who spoke up didn't even get to see what they were talking about. I mean, what I was just told was that we, members of Congress, weighed in on this, but we weren't even released the rule until after you voted. So to argue that you're somehow coming against 3 million Americans, they didn't get to talk about this. It was hidden, it was withheld, it was not disclosed. Is that accurate?
Congresswoman, I believe it is accurate. I think that many of the emails and letters we got, they had no idea of the full range of this Title II plan because it wasn't disclosed to the public. They had no idea exactly how it would counter interconnection, that it would tee up service plans for net neutrality violations, that it would include ex post rate regulation, that would include a lot of these different rules, which now we are seeing, now that the plan is public, some of the very same people, such as Netflix's CEO, Google's chairman just last week, have said, I'm a little antsy now about the government injecting itself into the internet, and unfortunately we had to pass it for the American people to see it.
So I've heard this before, we have to pass it to see what's in it. And the last time I heard that, I shook my head because I thought this is not a good idea, and now here we're finding out what's in it. You know, in that same, along that same line, you know, aside from the President's declaration, I want to know specifically if there are any events that led to the policy, I would say, policy shift at the commission. And we heard a timeline, May, November, and then February, and then the vote, and then we see it. In the spirit of transparency, is there a specific commission meeting that I can point my constituents to and say, this is where it happened, this information was unearthed, and we had to evolve from point A to point B behind closed doors? I mean, is there something I can point to them and show them?
Unfortunately, and I say this as somebody who both as a commissioner and a staffer cherishes the agency's independence, the seminal moment was the President's announcement on November 10th that he had a plan for net neutrality and he was asking the FCC to implement it. And that was the defining feature, I think, of this entire proceeding.
That's so disappointing. You know, I've heard a very good discussion on and I heard you mention, there are ways to make sure that consumers have choices, that they have better speeds, that they have lower prices. None of us want to see, we want to see that. We want to empower the consumers. And that's what's actually made the internet great, is that it empowers consumers. It's not the government empowering them. That's not us picking and choosing winners and losers. It is a free market tool that allows someone in their parents' basement, as was quoted over here, to compete because of their idea and their innovation with a well-established company. That's an amazing tool. And the reason you see such vigor defending it is because we don't want to screw it up. I mean, we've watched, the reason I believe this country is where it is because of the free market opportunity. It levels the playing field, right? One of the things I'm concerned about, and you know, we've talked about, I want to kind of put a different spin, is everybody uses the internet for different reasons. A grandmother in Castle Rock, in my district, a small rural area, may get online a couple times a week to check Facebook to see pictures of her grandbabies. That's when I think about my mom and how that's one of her uses, is to check up on her grandbabies. While a student at WC Vancouver may get online and want to download HD movies, maybe they have 10 hours until their paper's due and they need to do some serious research, right? They need to spend some quality time on the internet. What could the Open Internet Order's general conduct standard mean for service providers who want to offer varying pro-consumer plans to meet each individual's needs? I mean, are we raising the rates on grandma?
I think ultimately, Congresswoman, that is a key question. The Internet Conduct Standard is so vague that nobody knows exactly what it will prescribe and what it will permit. And I think essentially every Internet service provider in America is now going to have to funnel whatever creativity they have through the regulatory bottleneck of the FCC to figure out whether or not it's going to be allowed or not. The order itself tees up 7 vaguely worded factors, such as the impact on free expression that any service plan might have. But if you're a small ISP in a rural area, first of all, you don't have the cash to hire lawyers and accountants to comply with these regulations. But second of all, even if you did, the time it would take for you to get an answer back from the FCC could be prohibitive. And ultimately, it's going to redound to the detriment of those consumers who lack broadband options as it is.
One final, totally switching thoughts, question for Chairman Wheeler. You talked about your reducing the number of field director positions from 21 to 5, and the number of field offices from 24 to 8. I'm very concerned, living on the West Coast, because it said you're going to have the Tiger team in Maryland, which they can get on a plane, but I don't know if you've ever had to catch a plane last minute, or in inclement weather here, you're lucky if you get out and get to the West Coast, which is on a completely different time schedule, and as you can imagine, that's a major concern for me. I understand the field office has played a significant role when we're talking about FAA administration, experiencing interference when it comes to our Doppler weather systems. How will the commission continue to perform these important functions with this new plan, particularly in the Pacific Northwest, where now we're going to have 0 offices?
Great. Thank you very much, Congresswoman. It's an excellent question. As you know, we have a field office in Seattle today, staffed by 1 person. That person costs $190,000 a year to maintain there, and has the second fewest cases of any in the country, any field office in the country.
How many?
So you've
How
got
many?
to ask. It's the second fewest.
No, how
cases.
many requests?
One
does this
RF
person?
case per week. We have 1 person.
So about 52 cases in a year, and they serve all of Washington or the whole Pacific Northwest?
The Pacific Northwest.
Okay.
But as I say, it's the second fewest of any of the. So the question is, if we pre-position equipment there, and we can fly people in, what we're trying to do is to say, how do we evolve? Because 20 years ago, when this plan was put together, what the offices did was they went out and they inspected broadcast records. Well, those are online now, so you don't have to do it. They went out and they made sure that the lights were on in antennas. Well, there's now automated monitoring of that. And from those old-style kinds of activities, the new responsibility has increasingly become spectrum. And how do you deal with interference issues?
So those cases you're talking about, they're primarily spectrum cases?
Spectrum cases. And those can get dealt with on there is a concern, you go in and you deal with it, and then you move on to the next concern. Because they're not all in Seattle, as you know, they're all over the place. And so today we're flying people or driving people to deal with those cases. And we can do it from California, as efficiently as we can, more efficiently than we can from the other 24 offices.
I'm going to be watching this issue because actually I've never wanted to be lumped in with California when it comes to dealing with any major concerns. They tend to really house their own challenges, and they need all their people to take care of their challenges. So we like to maintain our autonomy, and this is an issue I'm going to be following closely. Thank you.
Thank you. And I think we have time for another round of questions if people have questions. I mentioned in my open remarks that our internet market exceeds Europe's, both in competition and investment. And Americans have more choices than their European counterparts. So that's a good, I think, point of comparison in terms of global competition. But they have restrictive type rules that just like the ones that we're adopting, and yet when you look, I think we've had 4 times as more capital investment, twice as much investment in mobile. In Europe, there's less competition, less access. So let me ask a question. This is Mr. Chairman Wheeler. You used to be president of I think it's called the Cellular Telecommunications and Internet Association, the CTIA.
Yes, sir.
And that's the trade association for the wireless industry.
Yes, sir.
And a lot of people are surprised that the fact that that was your former job, that you'd support not only classifying broadband internet under Title II, but also wireless internet. So I'm just curious, what, if you were still the CEO of CTIA, what would you be telling your membership about these rules?
Thank you very much, Mr. Chairman. Let me just clarify one thing. You said, I think, that these are just like, that Europe has rules just like the ones we're adopting.
Not just like, but I would say they have more restrictive rules than we do.
Yeah, and
Before.
no, and these rules do not move us towards that. We don't have rate regulation, we don't have tariffing, we don't have unbundling, we don't have all those kinds of intrusive things. What we do propose here is the same kind of concepts that Mr. Walden, Mr. Upton, and others are saying, which is the no blocking, no throttling, you know,
But more restrictive,
cetera.
you'd admit to that,
But
than we have now.
Yeah, and I hope that we're not going to have blocking and throttling, and that it's nothing like European. I met 2 weeks ago, I met with all the European regulators, and I can assure you it's nothing like what they have. But let me answer your question. One of my aha moments in this whole evolutionary process was my realization that Section 332, which, while I was the president of CTIA, I was advocating in behalf of the wireless industry for in this body, had done exactly what we ended up doing here, which was to declare wireless voice a Title II common carrier and to forbear from unnecessary regulation in the old style, from the old style of Title II. And that was a huge success. And so what we're doing is building on that model and the success of that model and saying that we think that will work for the internet as well. Now, you asked the question, why cover mobile? Because 55% of the access to the internet is now from mobile. And if mobile is going to be the internet future, which we all believe it is, then we need to make sure that there's one set of rules and that there is openness. I know from personal experience that in the early days of the mobile industry, in mobile data, that the carriers tried to build walled gardens and that you could only get on the network if you agreed to pay some kind of tribute in terms of revenue sharing. We can't have that imposed on the internet. And so the openness that all consumers have a right to, I believe, on the internet isn't constrained by whether you get it by wire or over the air.
Thank you. Let me just ask Commissioner Pai to comment on that. That in your view, do these rules seem to restrict competition? Are they more restrictive? I mean, in terms of competition, that you see them as a step back, and I don't mean to say we're looking just like Europe, but comment on where you think that leads us in terms of competition and in terms of restrictions.
That's a great question, Mr. Chairman. I think with respect to the comparison, the mobile aspect is highly telling. In the United States, 86% of Americans have access to 4G LTE. In Europe, that's only 63%, despite the fact that they have significantly higher population density. And that 63% is up from where it was just a couple of years ago. Secondly, in America, we have 30% faster speeds than you do in Europe. Now, also, with respect to the regulatory framework as applied to Europe, Europe doesn't have any mobile unbundling, all that kind of thing. So I think the regulatory comparison there is pretty apt. Secondly, in terms of competition, the American wireless marketplace is highly competitive. You see a great deal of competition on price. You see carriers spending billions of dollars upgrading their networks. You see spectrum auctions raising a lot of money. And the reason is not because mobile voice was classified as a Title II service. I mean, voice is the least important driver of the mobile revolution. It's mobile data. And mobile data has been historically unregulated. It has not been a Title II service. And especially with the inception of the smartphone in 2007, what you saw was consumers realizing, aha, this device that I can take with me is suddenly a substitute for all kinds of other wired internet connectivity. And so now you see people streaming video on their iPads and the like. It's the mobile data revolution driven by a light regulatory touch that has really spurred all of this investment and innovation. And that is what we're putting at risk when we say lump it in with the wired internet access providers. We're essentially saying mobile is just another pipe, so to speak, that should be treated like the water company or the electric company. I don't know about you, but I certainly don't think of those companies as innovative as some of the wireless companies that have delivered us the ability to do all kinds of things on a smartphone that were unthinkable just a decade ago.
Well, thank you very much. Mr. Serrano, do you have any further questions?
I do. Chairman Wheeler, my Republican colleagues, and I say this with all due respect, gave Commissioner Pai a lot of time to speak about his opposition to net neutrality. I'd like to give you a chance to respond to his comments. Also, can you comment on the public roundtables you had? I understand there were 6, and the reports and other information that was released by the FCC regarding Title II, even before the President's announcement.
Thank you very much, Mr. Serrano. Let me, a couple of things that I was lifting my finger for a moment ago. I was an entrepreneur in an earlier life. I spent the decade before taking this job as a venture capitalist backing early-stage internet protocol-based companies. Through this process, I met with hundreds of innovative startup companies and their financiers. And they were all uniform in the comment that permissionless innovation is what is key. That I don't have to go to the gatekeeper and say, well, is this the kind of service that you'll let through? Or is there a potential that you're going to charge my competitor something that will give him a leg up on me? And so on the question that Commissioner Pai was asked earlier about the impact on innovation, the key to innovation is open access. And that's what we provide here. Secondly, there was a question about rates for grandma. We're not going to regulate rates. Carriers are free to provide whatever packages they want. If they want to have an email-only package and then all the way up to some kind of super-duper online real-time game-playing package, I mean, that's fine. That's terrific. We hope to encourage that. And then insofar as the other comments you made about roundtables, we had half a dozen roundtables. I was the only commissioner that was at every single one of them for every single minute, where we brought in advocates on all sides and had mini hearings, if you will, to sit down and talk about technical issues, talk about legal issues, and talk about marketplace impact issues. And those were very helpful in informing the process.
Let me do something a little different, Mr. Chairman. For me to say that I didn't know that this was going to turn into a net neutrality hearing would have been foolish, because I know that that's the issue of the day. It did turn into that. But let me end on a perhaps an interesting note. What's next to both of you? What new gadgets, what new toys? We know there's a watch coming. We know there's a car that's going to park itself, wash itself, run itself, and the whole thing. What's next that the FCC will have to be looking at and be ready for?
You want to go first, or you want me to go first? Huh? Let's flip a coin. Go ahead.
Mr. Serrano, you better be careful. This could be some inside information.
This is, you got a couple of
But I'm not investing in it. So.
you got a couple
Neither are we, just for the record.
tech freaks up here, so.
One of the things I'm most excited about, Ranking Member Serrano, is unlicensed spectrum. I think the 5 gigahertz band in particular holds special promise for delivering some of these high bandwidth applications. Right now, we have some very complex issues related to the so-called Uni 2B and Uni 4 bands that, if we can resolve them, will deliver 195 megahertz of high delivery rate spectrum that could really revitalize Wi-Fi across the country. That's the thing that I'm most excited about in terms of the tech sector.
I think it is the marriage of two things. One, the power of Moore's law and how chips, computer chips, are doubling in capacity, in processing capacity every 2 years, which means that 15 years from now, they'll be 1,000 times more powerful than today, which is an amazing kind of thought. And secondly, wireless, and that those two coming together are the greatest transformational force that the planet has ever seen, and that it will enable the kinds of things that will use the kind of spectrum that Commissioner Pai was talking about, but it will enable the things that you and I have never even begun to contemplate. And everything will be connected, and everything will talk to everything else. And the most interesting things that flow out of that then are that creates new information. And so this becomes a network of that by the provision of services creates a new asset. And that's the first time in history that's ever happened. And secondly, it creates great privacy issues that we collectively in the Congress and the Commission are going to have to deal with.
Well, in closing, Mr. Chairman, I know my time is up. We have questions for the record, which we never got to, and I was part of it by asking the last question. I just hope that you do two things, that you continue to do the work you're doing, but that you also, both, the whole Commission, pays attention to our schools, pays attention to those who don't still have in this country access to the internet, to provide it for them, and remembers that the territories are parts of the United States too, and they get left behind on many occasions. And you knew I had to get that in. So thank you so much. And I must tell you that my Twitter stream has a lot of people watching because they've called us a lot of names, and they're mostly positive.
Thank you, Mr. Arnold. Now, Mr. Yoder has another question.
All right. Thank you, Mr. Chairman. I want to commend both of you on, I think, doing a very nice job today of laying out opposing viewpoints on an issue that is of critical importance to our country. And I think it's been nice to watch the interchange and debate, and I appreciate your testimony, both of you today. And you've articulated issues that I think has given both parties in this Congress things to think about on the other side. I will say that what continues to give me pause, and I think the net neutrality debate's a very interesting one, is the potential camel's nose in the tent regarding future regulation. And I think even Chairman Wheeler, you would be wary of the FCC expanding these powers, I hope. And so whatever the FCC can do, you know, obviously I've raised the issue of taxes and the USF fund. I've raised the issue of the cost to implement. But the potential to expand and control rates and all these things, I think, would make many of the proponents of this net neutrality proposal regret that the FCC took those actions to get there, because it could ultimately be a net loss in terms of freedom and opportunity here. So it's not just net neutrality. I think that debate's been very interesting. It's what else could happen. And we've seen agency after agency in this government take very limited powers and figure out ways to expand them. It happens at the EPA. It happens at every federal agency. And we wonder how the regulatory agencies end up getting away with all of this power, and they usually justify it by saying, well, someone gave us a broad power long ago, and we have the power to expand that within our own rules. And so I think Congress will really have to look at making sure that this expansion of power doesn't occur to some of these other potential problems that I think even proponents of net neutrality would be opposed to. That being said, I want to change the subject a little bit to the repacking spectrum issue. And Mr. Chairman, I think we can all agree that the broadcast incentive auction is a very important process for spectrum allocation, public safety funding, and debt reduction. However, when Congress authorized the incentive auction, we intended that local television stations who continue to serve their viewers and communities would be held harmless. Accordingly, Congress allocated $1.75 billion to the Television Broadcaster Relocation Fund to cover the reasonable costs that stations will incur as a result of changing channels. Some have estimated, though, using the FCC's own expert report as a basis, that repacking more than 1,300 stations to clear 84 megahertz of spectrum may cost more than $2.6 billion, leaving a shortfall of over $1 billion from the relocation fund, or more than $600,000 per station. If that's the case, the auction was intended to be voluntary, but if stations are enforced to cover their repacking costs, it doesn't seem very voluntary. So I guess my questions are, is there anything the FCC can do to limit the television station repacking to $1.75 billion? And if the incentive auction clears 84 megahertz of spectrum, will the relocation fund be sufficient to prevent broadcasters from being forced to go out of pocket?
You want to try that?
Commissioner?
somebody
The answer
wanted
is,
Either way.
sure. The answer is that, as you point out, $1.75 billion is a statutory number that we have to live with. Many broadcasters have said to us that it's insufficient. We have worked with the broadcasters and with the wireless industry to say, is there a way we can have an insurance fund? We can't redirect auction revenues to do that. So we said to the wireless industry, you guys are going to be the beneficiaries here. You're buying it, okay? Understanding that it's going to result in a decrease probably in what you would pay overall, but why don't you guys create some kind of an insurance fund? They have not been interested in doing that. This is an issue that we are going to have to deal with. We have a whole set of rulemakings that will percolate over the next half a dozen months, leading to an auction this time next year. And the other part about it is, if Congress can help us with this, we'll raise our hand and say, we'd love to work with you on it.
Commissioner?
I would add that it simply accentuates the importance of structuring the auction in a way that tailors the repacking to that $1.75 billion budget, because for every dollar above $1.75 billion that comes out of the broadcaster's pocket, that ultimately will get taken out on the viewers of those stations who have to see less local news, et cetera. And so I think it's important for us to use $1.75 billion as a marker, unless and until there are other initiatives that Congress sees fit to adopt.
Thank you. Thank you both. Thank you, Mr. Chairman.
Mr. Graves.
Thank you, Mr. Chairman, and I'd like to agree with Mr. Yoder on your discussion today, debate. Each of you have done a wonderful job of explaining your positions eloquently, and you clearly know the other person's opposing views very well, too.
Mr. Graves, we're getting a lot of practice.
We're getting a lot of time together. And but you've been very respectful. I know each of you have, and to one another. And this is a very passionate issue for a lot of different reasons. And in my case, I mean, clearly, I appreciate Mr. Pai's position, your advocacy, and side with you on that. And the reason primarily is I believe whenever you have very difficult, challenging decisions, such as the Commission was faced with in this, it's better to err on the side of less government intrusion in the marketplace. I just don't think you can go wrong when you lean in that direction, you err in that direction when there's clearly a lot of questions out there. But if I could just follow up with one other item and then make a statement, Mr. Chairman, and just because I think it's about transparency. A lot of this debate has been about transparency, and you know, in our district, my constituents want to know things are transparent, and they feel the overbearing federal government, and particularly here as an appropriator, transparency is going to be extremely important to us as a committee. And so, Commissioner Pai, you've said that in the past, orders issued by a bureau of the FCC could always go to the full commission for a vote. Is that still the case today?
It can, yes. If there's an application for review that is filed, the agency can address the Bureau's decision.
And so transparency will exist in that case?
I certainly hope so, and I think in addition to transparency, dispatch is a critical part of it. We can't just let that application sit there forever, and so that's something that, working together, we've been able to accomplish.
Well, I believe Ms. Herrera Butler brought up a great point about how there was a lack of transparency, is the appearance and perception and probably likelihood that the commission votes on something that is not released until a few weeks later, and that causes a lot of questions. And so, Mr. Chairman Wheeler, just know that the sentiment among my constituents is distrust. It really is. It's with the president, it's with the administration, and I know Mr. Serrano had a point earlier, or Mr. Fattah had a point earlier about it was 3-1 supported this process. Well, if I remember right, it was entitled Open Internet Order. Who's not for an open internet? and so that's where transparency and distrust sort of collide, because you feel like, yeah, I'm for an open internet, and now there's this collision of ideas out there that say, no, it's not that. It's going to destroy the internet, or it's going to create these burdens and barriers out there. So in this case with the FCC, I do not believe technology should be partisan whatsoever. This should be a bipartisan effort, and it's my belief that if there were changes made to the process, if there were parameters in place to ensure transparency, then it would be much easier for myself, and I know my colleagues here on this panel and the chairman of the committee here, to embrace the budget request as you've presented. But lacking that, I imagine there's going to be some changes made or suggestions, and we're going to continue this debate in the future. So, Mr. Chairman, I appreciate the time today.
Do you want me to respond to your?
Feel free.
No, I thank you for your very valid point, Mr. Graves. I think there is a misunderstanding abroad about the process that we followed. The process we followed insofar as the release of the item is the process that has been followed for every other proceeding at the FCC, large and small, whatever it is. And the information leading up to it was the most open and transparent debate that we've had. I mean, we had full involvement from members of Congress. I mean, I was constantly up here being told what to do, and I appreciate entirely your point about openness, because it is the key to credibility.
Could I just
Hi,
comment?
Commissioner Pai.
Thank you, Mr. Chairman. I think transparency is a critical issue because it goes to the basic questions of, can citizens trust their government? And in this case, part of the reason why I said that the plan should be made public so that the American public can weigh in on it, on its particulars, not just the concept, was because it affects something so critical to American life. And that's why I think it's significant that, for example, Peter Hart, a respected Democratic pollster, found that 79% of Americans, regardless of what they thought of the actual rules, thought that the net neutrality plan should be made public. And tellingly, by a 23% margin, they believed that the order itself was inappropriate, that we should have gone a different way. Now, moving forward, the question is, how do we change our processes, if at all? And one of the things I've heard a lot about, and I agree with, is that going forward, the FCC should do something similar to what Congress does. When you drop a piece of legislation, you put it on the website, people can comment on it, then you have a markup where all the language is out there for people to see. Well, what if the FCC did something similar? 3 weeks before a scheduled FCC vote, we say, here is the proposal we're going to be voting on, the actual document. America, tell us what you think, and we'd be happy to get your input. And then by the time we vote, no one can say that they weren't apprised fully of all the particulars. That's something where even if people don't agree with what the FCC ultimately does, nonetheless, they would have the ability to say that they were informed about what was about to happen. And that can go a long way to restoring trust.
Thank you. And I have one last question about direct appropriations. I think, as Mr. Serrano pointed out, we've talked a lot about net neutrality, which is a rule. But as we said early on, this is the committee that decides where the money comes from to go to do things like proposing rules. So let me get back to just one last little specific appropriations aspect, and that's the move, the restacking or the move. And there's $44 million of requests there that I think it points out that it'll cost $71 million over a 2-year period to move, and ultimately that'll save $119 million over a 15-year period. So just for the record, tell us a little bit how you, did you come up with those numbers? Does GSA, where do those numbers come from, and where are we? I think OMB is reviewing that now.
Thank you, Mr. Chairman. This is a process that we're working through with GSA. I mean, we're not the the landlord experts here.
Not the real estate people.
We're not the real estate people. But our Office of Managing Director, working together with GSA, has developed these numbers, and we're following the processes of GSA in terms of what you do about location, relocation, or whatever.
Gotcha. Well, if there are no further questions, let me just add my words. Mr. Toronto?
Can I just say, only because, very briefly, because I don't want to take advantage of the chairman. Are we going to get any closer to the kill switch on smartphones? For those who may not remember, the kill switch is an issue where phones are stolen here, they're sent overseas in many cases, they're restarted over there, and the kill switch would not allow that to happen. I know some manufacturers are doing it on their own. Are we get any closer? I know you guys have been talking about it.
So, Mr. Serrano, July of this year, the carriers have told us that all phones going forward will have remote lock, wipe, and restore capabilities. Beyond that, however, there is a standards group in the wireless industry called 3GPP, which has said that they will come back by the end of this year with an identification system that is even better than that and becomes like the non-wipeable vehicle identification number that we now have on automobiles that were so successful in automobile thefts. So we're making progress.
Yeah, it's what we're hoping for is, and I'll close with this, that it's the kind of technology that it's not allowed to, just wipes it out and locks it and does not allow anyone anywhere else to restart it. Mr. Chairman, Commissioner Bratton from New York at a press conference we had with the Attorney General of many states says that 30% of all robberies in New York City were of smartphones.
That's right.
Well, again, thank you for your testimony today. Thank you for the important work that you do, and we appreciate you being here to share that with us today. This hearing is adjourned.
I'll tell you, we should look into this monetization thing. Raise some money, we give them a cut so we can,
Give them a cut.